Hello, and welcome to this fourth and final part of the history of juvenile justice. This is Dr. Bryson. In this video, we're going to look at the juvenile court era to the present time. The era of the juvenile court. The era of the juvenile court begins with the passage of the Illinois law in 1899. The Cook County Juvenile Court began operation in 1900. During this time, juvenile justice was an informal process. The focus, it was claimed, was on rehabilitation. The belief that juvenile behavior was malleable was still used as a justification for the informality of the system. During the 1950s, there were several films that illustrated this ideal. The public believed what was portrayed in the films. In 1959, the film A Summer Place was released and portrayed teen angst related to sexual tension. Splendor in the Grass, 1961, shares the story of teen angst related to a romantic relationship. But Rebel Without a Cause, 1955, is the most significant of the films for our purpose here. The opening scene of this film exhibits Jim, played by James Dean, as a teenager at the police station after being arrested for public drunkenness. His family arrives, and the juvenile officer speaks with Jim privately in his own office. During this scene, we witness Jim try to hit the officer. Jim misses and falls to the ground. Instead of restraining Jim, the officer removes his jacket, places his service weapon in a desk drawer, and says to Jim, quote, "I wish you'd connected. Maybe it would have given you some self-confidence," end quote. During this scene, we also see the conflict within Jim's family that is a part of the problem. Natalie Wood plays a teenage girl in the same scene, and we learn that her problem is a father who is emotionally distant. The scene is consistent with what the public believed juvenile justice was like at the time. In March 1954, President Eisenhower appointed Earl Warren to be the Chief Justice of the U.S. Supreme Court. Warren arrived at the court after oral arguments in the case of Brown v. Board of Education. However, the case had not yet been decided. Warren convinced the court to vote unanimously to end segregation in schools. The Warren court took a more active role in corrections and ended the hands-off doctrine within the adult correctional system. It was during his tenure as Chief Justice that the deeply held doctrine of parens patriae was challenged. The first case was Kent. In this case, the juvenile had been waived to adult court but had not been given a hearing, was not represented by counsel. Counsel did not have access to the records that were used by the juvenile court for the waiver, and the waiver did not specify the reasons for the transfer. The U.S. Supreme Court held that juveniles had all of these rights. The most significant of these cases was the Galt case. Gerald Galt was 15 years old when his neighbor called his probation officer, claiming that he had made an obscene phone call to her house. This was in 1964. Without being permitted to call witnesses or face his accuser, Galt was found guilty and sentenced to the Juvenile Detention Center for the remainder of his youth. That meant he would have to remain until he was 21 years old. There was never enough evidence to convict Galt in adult court. However, had he been convicted in adult court, the most severe punishment he could have received was 2 months in jail and a $50 fine. The U.S. Supreme Court held that Galt should have had due process rights, noting, begin quote, under our Constitution, the condition of being a boy does not justify a kangaroo court. The third case that ended the child saver's version of juvenile court was Winship. In this case, the court held that the burden of proof for juvenile cases must be proof beyond a reasonable doubt. Get tough on delinquency. While the Warren decision and Galt envisioned a juvenile justice system that provided due process rights to juveniles while recognizing their malleability, the results were very different. On the contrary, the addition of due process rights had negative consequences on juveniles. More juveniles were transferred to adult court, sentences for juveniles became harsher, and this included the death penalty and life without the possibility of parole sentences. With these changes in the 1970s and 1980s, the public began to take notice of juvenile offenders more than in the past. By the early 1990s, scholars and politicians were talking about the super predator. In fact, when Bill Clinton was running for his first term as president, Hillary Clinton, in a speech, talked about the super predator. Around the same time in Chicago, Yummy Sandifer came to the attention of the nation on the cover of Time magazine. Yummy was a very young but committed a serious murder. Intending to assassinate a rival gang member, he shot and killed a little girl. The gang realized that he was bringing too much attention on them, and they assassinated him. The only problem with the idea of the super predator, by the way, is that it was not accurate. Juvenile crime rates were in decline at the time, including violent crime. Modern reforms. This brought a period of modern reforms in the juvenile justice system beginning in the early 2000s. We began to focus much more on true rehabilitation. There was an increased belief in the malleability of juvenile behavior, and the United States Supreme Court began to take note of how juveniles were treated in the juvenile justice system. Two Supreme Court case decisions are important to understand at in this point in history. In 2005, the United States Supreme Court banned the death penalty for crimes committed before one's 18th birthday. In their decision, the court held, quote, "Respondent and his amici have submitted, and petitioner does not contest, that only 7 countries other than the United States have executed juvenile offenders since 1990. Iraq, Pakistan, Saudi Arabia, Yemen, Nigeria, the Democratic Republic of Congo, and China. Since then, each of these countries has abolished capital punishment for juveniles or made public disavowal of the practice. In sum, it is fair to say that the United States now stands alone in a world that has turned its face against the juvenile death penalty." In 2012, the United States Supreme Court banned mandatory life in prison without the possibility of parole for crimes committed before the 18th birthday. The court held such mandatory, begin quote, "such mandatory penalties, by their nature, preclude the sentencer from taking account of an offender's age and the wealth of characteristics and circumstances attendant to it. It is a misunderstanding to believe that Miller v. Alabama banned life without the possibility of parole sentences for juveniles. It only banned mandatory life without parole sentences. I hope that this very brief history, it might not have seemed brief to you, was very helpful. We will see you next unit.